Some days you just don't feel like cooking. Ordering a pizza is so much easier after a long day. Going through the drive-thru saves you from having to cut up the ingredients, warm up the oven, clean up the kitchen when you're finished. I understand, quick and convenient is sometimes the way to go for a meal, but it's not something you'd do all the time or else your clothes wouldn't fit and your doctor would not like your blood test results. So quick and convenient should be limited to the occasional meal. I see quick and convenient fast food estate planning all the time. I'm Patrick Cawley. I'm an estate planning and elder law attorney with Keystone Elder Law in Mechanicsburg, Pennsylvania. It seems like not a week goes by where at least one client doesn't tell me that they added a child as a joint owner to their financial account, usually a bank account, maybe an investment account. Sometimes they even add children as co-owners on the deed of real estate. And the reason they do this is because they found out you can do that and it's a convenient way to help your bills get paid. You know, the child can run to the bank and take out money, and it's just easier that way. You have the child who's helping you anyway. Why not give them ready access to the finances? Here are 5 ways that goes wrong. It's like the long-term consequences of relying on fast food for your health. Well, fast food estate planning goes wrong in 5 ways. The first is, well, family dynamics can change. So that plan works great as long as you and the child who's now a joint owner of your money is working in your best interests. But if they suddenly decide that they've been doing so much to help you that they deserve some of that money, that they should start spending it on themselves, well, there's nothing unlawful about that. There's nothing to stop them because it's their money. They are a joint owner of the account, even though the money in that account is really your hard-earned savings. So you don't want stress in the relationship with your child to turn into them taking the money out because it's theirs. If you instead had a power of attorney that allowed the child to access your account for all the same reasons, but only your name is on as an owner of the account, well, then there's real consequences in court for the child abusing that power of attorney, but not so if they're an owner. The second way that fast food estate planning can go wrong in the form of joint ownership is what happens to your estate plan. If you have it all thought out that you have 3 kids and you want to divide your estate 3 ways when you're gone, but then at the end of your life you only have all of your money in one account or 1 or 2 accounts and this one child is a co-owner for convenience, well, your will is meaningless because nothing goes through the will. There's a surviving owner. So that child keeps all of that money. Now, out of the goodness of their heart, they could distribute money to their siblings, but they're not legally obligated to do that. And then maybe that's going to cause infighting among your children. Number 3, the third way that joint ownership as a quick and convenient form of estate planning can go wrong is, what about if you need long-term care? Most adults do, and it's very expensive. Medicaid will pay for your long-term care if you follow certain strict financial guidelines. One of those rules is you're not allowed to give away money and then turn around and ask for help from the government to pay for your care. So in the last 5 years before your Medicaid application, have you created or have you transferred something of value to your children? Well, if you put them on the deed to a house or if you made them half owner of a large bank account, then yes, you made a very big significant transfer of property interest to another person, and that will turn into a penalty period where Medicaid won't pay for a certain period of time for your care. The 4th reason why joint ownership goes wrong as a quick and easy form of estate planning is simply that your child's creditors are now your creditors. So anybody who feels that your child owes them money, maybe a lawsuit because of business dealings, lawsuit because of a car accident that insurance didn't completely cover, or even a divorce where there's a distribution of property between your son and his soon-to-be ex-wife. They're coming after the money that has his name on it. And if his name is on your account, that money could get wiped out, even though it's your money. It can be undone, but that means going to court. That can be expensive, and it's certainly a hassle. The final reason why quick and easy estate planning in the form of joint ownership goes wrong is you might not have thought about this, but what happens when your grandchild applies for financial aid for college? Well, they have to list all the assets of their parents. If one of their parents is on your bank account, you've just inflated the assets of their parent and therefore made it a little bit harder for them to get financial aid. So there's all these little things that people don't think of when they go the quick and easy route. It's much better to bring on a professional who does this all the time to help you think through all of these issues before you commit to an error that could really haunt you, because this is everything that you own. If you need any follow-up advice, if you want to bounce some ideas off of us, send us an email at info@keystoneelderlaw.com or give us a call at 717-697-3223.